Please be seated. Just before I call on Mr. Hutley, Mr. Garris, there's some further matters following on from our dialogue with Mr. Dharmananda yesterday that we would be assisted by some further submissions from Crown, and we're happy for these to be taken on notice and for a written response to be provided. But there are 5 questions. The first is this, that the issue was raised concerning perceived departures from the trust deed, and Crown's submission was to the effect that the departures, if there are any, are cured by consent because all 3 entities, that is BNL, BRML and BL, are party to the arrangement that is in fact in operation. So the question that arises from that is this: is it more accurate to characterise it in terms of waiver rather than consent? The second question is that Crown says that for all practical purposes, the 3 entities work collectively, and that's the phraseology that's used in the BL's board charter, and that's of general across-the-board application. So 2 questions arise from that. Could that be characterised as a de facto amendment to the trust deed because of its ongoing and across-the-board operation? And if that is so, what is the impact of clauses 17.1 little c and little d of the state agreement? The third question is related to that, and if that is the proper characterisation, what impact, if any, is there of the parliamentary ratification of the 1997 and or the 2003 changes to the state agreement? The fourth question is this, is that in that working collectively scenario, could issues, and I stress the word could issues arise about merger of interests in the trust? And the final question concerns the term the business of Burswood Limited. The third paragraph of clause 3 of the board charter relates the business of Burswood Limited to the casino licence, and in the fourth paragraph it says that references to the business of the Burswood Limited are references to the businesses conducted by the Burswood entities collectively. Now that leads to 2 specific questions. Is this a working description, albeit in brief summary, of the business? And it's this: the conduct of casino operations and the resort facilities, including food, beverage, entertainment and related facilities. And the second question is this the business of Burswood Limited for the purposes of Article 3.12? As I said, we are quite happy for you to take those questions on notice, and if a written response could be provided by the close of business tomorrow, that would be greatly appreciated. Thank you. Now, thank you, Mr. Hutley. You wish to make some submissions on behalf of the CPH parties?
Thank you very much. As you'll have seen from our summary document supplied, there are 4 topics which we propose to address, and I won't repeat what those topics are. So could I turn to the first, which deals with our submissions as to the limits of the suitability inquiry. We've outlined in our primary written submissions, paragraphs 9 to 21, our central point, namely that the CPH parties and CPH's shareholding are not relevant to the current suitability of the relevant Crown entities. We embrace the observation made by the Commission in its closing observations, and Your Honours, Commissioners, you'll find that at Part A, Section 3, page 239, paragraph 336. There seems to have been an original version, and if you're using that, the relevant page is 233. That observation was that by reason of the resignation of directors and senior management and undertakings and arrangements that are now in place, any influence Mr. Packer, or for that matter CPH, had or may have had in the past is no longer extant. We may say the matter can be taken, in fact, a little bit further, should that be necessary. Not only is whatever influence those parties had no longer extant, so long as the undertakings properly understood are in place and complied with, and there's no suggestion made that they wouldn't be complied with, that influence has ceased permanently. It is extinct, not merely dormant. There's no suggestions that the undertakings, as I've submitted, will not be complied with. Thus, not only are we irrelevant to the current suitability inquiry, there is no reasonable prospect we could ever again become relevant to a suitability. Now, thus, the kind of factors which the GWC refers to in paragraph 56 of its reply submissions may be relevant to the question of suitability, for example, the role of individuals in engaging in conduct, were not examined by the Commission in respect of the CPH parties in a relevantly current way. That approach was, with respect, appropriate, given that that organisation, that is CPH, no longer plays any role other than that of a shareholder in Crown. That's all we wish to say on the first point. We wish to make some observations on our second point, namely the limits of the use of prior inquiry's findings. We acknowledged, of course, that the terms of reference require this Commission to have regard to the Bergen report. Significantly, the terms of reference also require the Commission to have regard to public transcripts and other materials considered by the Bergen inquiry, in respect of which this Commission has been able to access and considers it appropriate to have regard to. That's terms of reference, paragraphs B, Roman 1 and Roman 2. Thus, in respect of the findings in the Bergen report, in accordance with the terms of reference, this Commission needs to A, firstly, obviously, understand the findings that were made in their context. Your Honour, you will have seen we have made submissions, and I won't go over them, in respect of some references to the findings in the Bergen report, which we with respect submit have been, by those relying upon them to a degree, taken out of context. That's the first thing, namely understand the findings that were made in their context. Secondly, at least where that finding is relevant but disputed, avail itself of access to all materials to determine for itself the correct position. Indeed, the terms of reference direct this Commission to consider the materials sitting behind the Bergen report if this Commission considers it appropriate. That is an acknowledgement that the Commission may consider whether some or any finding made in that report is sound or unsound. Where a finding is challenged, and we have challenged a limited number of them, and that challenge is supported by reference to materials which were before the Bergen inquiry, we submit it would be appropriate, in the sense used in the terms of reference, for the Commission to have regard to the underlying material as a matter of procedural fairness, and then address its consideration of those findings in the context of the contest raised by the submissions and materials adverted to in those submissions. Further, whilst the terms of reference permit regard to be had to the Bergen findings, they suggest no canonical preference for findings over other materials. No greater weight should be given to the findings. If a finding was made and the Commission is satisfied it was made either contrary to the materials or it cannot be satisfied one way or the other, no weight should be given to the finding. Although not explicitly mentioned in the terms of reference, a similar approach we submit would apply to any findings of other bodies, such as the Victorian Royal Commission. Turning to a few specific concerns with which the CPH parties have with the findings of other bodies, those are dealt with in part 3 of our primary submissions. We don't propose to say anything further about those matters other than respond briefly to some matters raised on behalf of Mr. Craigie in his reply submissions of the 27th of January 2022. And if you have those before you, I will be referring to a number of paragraphs, and it might be convenient for you to have those paragraphs. And I'd first go to paragraph 5A in those submissions, which I think you'll find on the first page of those submissions. Mr. Craigie submissions deny his involvement in the establishment of the working. We submit he overlooks that Mr. Johnson gave evidence in the New South Wales inquiry that Mr. Craigie suggested the initiation of that very group, together with Mr. Packer. Mr. Nielsen also gave evidence to that effect in this commission. Now, we give the evidentiary references at footnote 50 in our primary submissions. And if you just take those up, you probably and make a note, either if you can make a note over them that's electronic or in handwritten writing. There's a typographical error. The relevant paragraphs of Mr. Johnston's third statements are paragraphs 14 and 15, not paragraph 13. Mr. Craigie made no challenge to that evidence in the New South Wales inquiry or in this commission, nor is there any inconsistency with Mr. Craigie's evidence in that inquiry, as he suggests. In fact, that evidence acknowledged that he went to the first 2 meetings of the VIP working group. And commissioners, you'll find that in the New South Wales inquiry transcript, page 1460, lines 27 to lines 30. Returning to Mr. Craigie's submissions, here, paragraph 5B, Mr. Craigie appears to contest in an unspecified way Mr. Packer's evidence in the New South Wales inquiry regarding oversight of Crown's operations in China, and that when Mr. Packer became aware of the Korean arrests, he tasked Mr. Craigie and Mr. Rankin to look into the matter to ensure that Crown was not at any similar risks. Now, you will find the reference to that evidence at footnotes 161 to 164 of our primary submissions. Again, if you take those up and look at footnote 164, there's a reference to transcript 3608 of the evidence of Mr. Packer in the New South Wales inquiry. There's a reference there to lines 37 to 39, it should be 27 to 28. Apologise for this. These enormous work was done. It's understandable there is the odd proofreading error. No contest of the variety now made was made in the New South Wales inquiry by Mr. Craigie, nor did anyone else contest the evidence to which we've made reference. And in fact, it seems to have been accepted in the inquiry report, and you'll see that at chapters 3.3, paragraph 221. We won't go to it. But I now turn to paragraph 5C of Mr. Craigie's submissions. That relates to Mr. Packer's evidence regarding Mr. Craigie's oversight and responsibility for risk management of the Perth casino, and Mr. Packer's evidence that he looked to Mr. Craigie for guidance on compliance and corporate governance matters. There is, contrary to the submissions of Mr. Craigie, no inconsistency between Mr. Packer's oral evidence and his witness statements. That evidence you'll see at footnote 165 of our primary submissions, and you can compare that evidence to paragraph 47 of Mr. Packer's witness statement to this commission. Mr. Packer's evidence as regards Mr. Craigie was in substance no different to the evidence Mr. Packer gave to the New South Wales inquiry. And can I give here a list of transcript references? And these things tend to sound a bit like ones at some form of housey evening, or would it be better that we just send the commissioners a short list of them rather than, because there's about 6 or 7 references, and it might be better if we send you a note on the question.
If there's only 6 or 7, just give them to us, I think, Mr. Hutley. Thank you.
Whatever. Yes, in the inquiry transcript, New South Wales inquiry transcript, 3,600 line 30, 3,602 lines 43, 3,604 lines 19 to 3,000 to lines 27, 3,608 lines 26 to 34, 3,612 lines 4 to 10, and 3,000 and lines 32, and sorry, 3,612 lines 32 to 39. And no issue was raised by Mr. Craigie in the inquiry before Ms. Bergen on that issue. I now turn to paragraph 5D of Mr. Craigie's submissions. He there suggests that there is no corroborating evidence of Mr. Packer's evidence of almost daily conversations between them. Whilst one wouldn't expect corroboration, it's unclear whether it's seriously disputed that he would have been in regular communication with Mr. Packer when Mr. Packer was the executive chair of Crown Resorts and Mr. Craigie was its CEO. Finally, as to paragraph 5E, Mr. Craigie raises what we submit as a quibble as to the characterisation of Ms. Coonan's evidence that Mr. Felstead reported to Mr. Craigie in relation to board meetings and nobody else, in that she did not explicitly say Mr. Felstead reported to nobody else. Now, if in answer to a question, a person says, to whom did you report in relation to X? They say, I reported to Y, and refers to no one else. I wouldn't infer that an answer by such a person indicated that she was saying he reported to Y and possibly many others. We say the point is of no significance. You'll see a reference to Ms. Coonan's evidence at footnote 221 of our primary submission. I won't go through it. Now, can I now turn to our third topic, shareholder caps. This is dealt with in part 2 of the CPH party's primary submissions, and we'd just like to emphasise parts of them now. By shareholding caps, we mean either a hard cap on permissible shareholding in a casino licensee or a holding company, or amount at which shareholding in the casino can only be obtained with approval of a regulator, which is less than what the Casino Burswood Island Agreement Act of 1985 presently requires. We submit that no such recommendation should be made. And first, the Commission did not inquire into any party's ability to influence the management and operation of the casino by reason of its shareholding. In our submission, recommendations about shareholding caps can only be properly made if it is first established there is or is likely to be a deleterious effect of a party's influence arising from its shareholding. Absent any found detriment or likelihood thereof, from the mere existence or exercise of that voting power, it would be a significant step for the Commission to recommend limits on a company's ability to raise capital and a person's shareholding because, for example, the mere theoretical possibility of adverse influence. A fortiori, if there is no theoretical possibility of adverse influence. The point was made by GWC at paragraph 62 of its reply submissions, and if you'd go shortly to it, if that's conveniently available, where it says that, I quote, simple limits on equity ownership may not reflect the realities of control and influence that may be exercised through relationship or economic interests. That where there are, for example, constraints which neutralise even theoretical possibilities, it is even greater reason not to submit controls. We say that there is no evidence that equity ownership levels created any of Crown's issues, and nor should it be thought that capping equity levels provides solution to such issues. Secondly, there is no evidence before this Commission, and there was no evidence before the Victorian Royal Commission or before the New South Wales inquiry, that CPH's mere shareholding had influenced Crown's culture or that it prevents Crown from embedding cultural change. There was no finding of either the Victorian Royal Commission or New South Wales inquiry to the effect that CPH's mere shareholding influenced Crown's culture. Indeed, the New South Wales inquiry did not even recommend the cessation of CPH nominees on the Crown Resorts board and proceeded on the basis that 2 such nominees would remain. And you'll see that at chapters 4.3.5, pages 467 to 68 in paragraph 11 of that report. Thirdly, in our respectful submission, recommendation 28 of the Victorian Royal Commission relied, which has some significance in the submissions of on this topic, relied on a critical matter which was wrong. I don't know if you have that available to you, the relevant part of the volume 1 of the Royal Committee, the report, the Victorian report. But if you do have access to chapter 17, and particularly internal page 33 over to 34, which deals with recommendation 28, at paragraphs 84 to 85, the position of CPH is addressed. There are two grounds placed as justifying the position with respect to Crown CPH's interest. The first is the first sentence of paragraph 84. I won't stay to debate that, which is a factual matter which, whilst we may contest it, is not to the point here. But on the second point is, it says, on the other hand, once its undertakings to ILGA lapse, the position of control would be restored. That could be detrimental to Crown Melbourne. So fundamental to the recommendation of the Victoria Royal Commission was an assumption that the undertakings to ILGA, that is to the New South Wales Commission, would lapse. That seems to have proceeded from the assumption that those undertakings had a temporal aspect, other than the undertaking concerning voting with respect to directors and nominees. There was no temporal limit to the undertakings. And with respect to the directors aspect, the temporal limit was 2026, and then only with the approval, in that case of ILGA, and in respect of all other profit undertakings, each regulatory body of concern, namely the Victorian, Western Australian and New South Wales bodies. So with all due respect to the Victorian Royal Commission, that recommendation proceeded on a fundamental, with respect, misunderstanding of the ILGA undertakings. Now, fourthly, to impose a shareholding cap is to restrict a prospective shareholder's ability to buy shares and to restrict a company in who the cap to which the cap applies to raise capital freely. No evidence has been provided, so there has been no consideration of the economic effect that might have, let alone how a sell down might work and the adverse effect any sell down may have on price. Fifthly, were any such shareholders' cap recommendation to be countenanced, there are good reasons why it would not operate with respect to existing shareholders. And I won't repeat here, but CPH's theoretical adverse influence that could arise from it has been removed for the reasons which we've adverted to, namely their ceasing to participate in the organisation through nominees or the like, and the undertakings which we have referred to, which has resulted in the fact that they relevantly have ceased to be persons of relevant to the consideration of whether the entities, the subject of this inquiry, are suitable persons. Now, sixthly, we submit the Commission has not itself undertaken any inquiry into any historic influence of the CPH parties in the affairs of Crown, and no CPH person has been called to give an evidence in relation to it. And that we submit. And finally, there is significant complexity to be considered in recommending any shareholding caps under the Casino Control Act, given they should be harmonious with threshold caps for takeovers and acquisitions of relevant interests under the Corporations Act, Foreign Acquisitions and Takeovers Act, and capped shareholdings in the Casino Burswood Island Agreement Act. And the absence of any analysis in the closing observations as to the current legislative regime under Section 17 of the Casino Burswood Island Agreement Act. And it hasn't been referred to. If you take a moment to look at them, I won't purport to analyse them. But if the Act is conveniently available to you, Section 17, 1, deals with questions of disposure. Now, the fact that that has not been the subject of analysis or inquiry is an indication that this issue of caps and the appropriateness of caps and should different arrangements be put in place is indicative that this is an issue right for consideration by the Commission. Now, that's all I wish to say. And now can I turn to our final point? That concerns the GWC submission as to the recommended legislative amendment. Our first submission is that this question does not fall within the terms of reference of the Commission and should not be the subject of a recommendation of a legislative amendment, so that Commission is treated as if it were a Section 21A5 inquiry under the Casino and Control Act. We've dealt with this in writing in part 1 of the CPH parties' submissions, or reply submissions, and we also adopt Crown's reply submissions dated the 27th of January 2022 at paragraphs 8 to 13. Can I say something shortly about the oral submissions on behalf of GWC yesterday, where they stated that the amendment they seek is similar to the amendments made to the Casino Control Act 1991 Victoria. There are a number of problems with that submission. Firstly, just because amendments were made in Victoria does not overcome the problem that it is not within the terms of reference for this Commission to make recommendations about how its report be treated at the time of any potential future consideration by the Minister of the exercise of his, or at that time hers, whoever be the Minister's powers under Section 21B of the Casino Control Act. GWC relies on terms of reference 7, which enables this Commission to examine, and I quote, matters reasonably incidental to, unquote, the suitability matters. This suggested recommendation would not be reasonably incidental to the suitability inquiry, because it is about consequences after any such decision is made as to suitability by another decision maker at a different point of time. GWC also relies on terms of reference 11, which relates to matters which might enhance the regulatory framework and GWC's future capability and effectiveness in addressing any of the regulatory matters. The recommendation goes beyond the regulatory framework or GWC's future capability and effectiveness in addressing regulatory matters. It goes to the ministers to power to in effect impose penalties and consequences arising from this report. Next, in Victoria, amendments were made to make findings and recommendations of the Victorian Royal Commission grounds upon which VCGLR could take disciplinary action as they're defined, which include the power to impose penalties and the powers for suspension and cancellation of casino licences. And if the Commission has that, the Casino Control Act, if they have the, where's the Casino Control Act? Sorry, I'm just turning it up. The Casino Control Act 1991, the relevant section is section 20, as in its current, in an amended form. Is that the amended form? Yes, sorry. Yes. And the relevant sections are, yes, subsections 11 and 14, but to understand them, one has to deals with the definitional clauses in subsection 1, and one will see there the definition of disciplinary action if the Commission has access to the section, and grounds for disciplinary action. Now, however, when one looks at those sections, they are in contrast to what the GWC seeks here, which is to have this Royal Commission deemed to be an inquiry under section 21A5 of the Western Australian Act. The GWC seeks more than the mere addition of a ground of the minister's action, but that a statutory precondition to the minister's exequatur be changed. Thirdly, and notably, under the new sections 20, subsection 11 and 12 of the Victorian Act, the VCGLR cannot cancel or suspend the Melbourne casino licence using the findings or recommendations of the Victorian Royal Commission report as a ground, unless a recommendation has been made of the special manager to do that, or if the disciplinary action arises from a request from the minister following an investigation under section 24 of the Victorian Act. In contrast here, the GWC does not appear to suggest any limits on the use of the Royal Commission's report. It seeks the Royal Commission be deemed as the section 21A5 inquiry, apparently to minimise legal challenge to a potential decision of the minister. And that, of course, deprives one of its important procedural rights. Now, it is not and has not been the function of this Commission to consider the Victorian Act and whether it considers that Act is a wise or appropriate response to the issues raised before this Commission. And were it part of the Commission's function, one would firstly have to, as it were, understand and analyse how the Victorian Act operates, and secondly, whether it was, in the view of the Commission, an appropriate response to the issues which has come before this commission, because this question has not been, until effectively final submissions, conceived of as being part of the this inquiry. None of that has occurred. And so that again points up the inappropriateness of issues of this importance being taken up, as it were, at the very heel of the hunt in final submissions. We have not, because of that, subjected to critical analysis the legislative response in Victoria, nor has anyone else. So I don't comment upon it, but merely to observe that that which the Commission, the GWC, here promotes is quite different to the response in Victoria. Those, if it pleases the Commission, are our submission.
Thank you, Mr. Hutley. Mr. Jenkins?
Yes, thank you. Mr. Hutley, it's just one issue that I want to explore with you. It is in respect to your submissions about the shareholding. Whether it would enhance the regulatory framework to have different shareholder caps is one matter. The other issue is whether it is necessary for the PCRC to consider a recommendation such as was made by Commissioner Finkelstein in respect to CPH's shareholding in CRL. And one way that the PCRC might look at that issue is that in the light of Commissioner Finkelstein's recommendation that CPH be required to sell down its shareholding in CRL, and in light of the Victorian government's comments that it will implement the recommendations of Commissioner Finkelstein, that issue is done and dusted, so to speak, for the PCRC, because if that recommendation is implemented, CPH will have to sell down its shareholding in CRL. Why shouldn't the PCRC simply take that approach? Is there an implication in what you're saying that recommendation will not be implemented by the Victorian government?
Mr. Jenkins, I would not, I don't know whether it'll be implemented or not. I certainly can't suggest it would. It won't be, but that's a matter of politics. And that if it is implemented, then it will be a law, a law of the state, and it will have whatever compulsive force it is, in whatever form it's taken up. But the question here is, in our respectful submission, whether this commission should recommend such a law. And if this commission sees that, for example, that recommendation, as we submit is clear, seems to have proceeded on an erroneous assumption, namely that there was a future risk of restoration of the predicate assumption of improper exercise of power, and that was the predicate. There are two reasons. Then if one was wrong, and the only fact was that there had been past matters of concern, then this legislation to compel sale of shares is nothing more than punishment. Whereas if it's based upon a threat, it may be something different. There is no reason for this commission is not concerned with what the legislature of Victoria might or might not do. That will be a matter for the legislature of Victoria. And if the legislature of Victoria undertakes that, that will have a consequence. This commission is concerned as to what's appropriate legislation. On one view, if the Victorians go forward with their requirement, this legislature can say, well, we don't need to concern ourselves with this at all, either agree or disagree with it. We won't make any recommendation because whatever will occur in Victoria. So, but there is no reason in our respectful submission for this commission to, as it was say, because Victoria says it will do something, we will fall in with it. So we'd say it would be a wrong approach to take that. This commission, in a sense, and can I say, we submit, if this commission forms the view that the Victorian recommendation was based on a predicate error and observed upon that and didn't adopt that coast because of that, that might have political implication, I can't speak to them, across this country. So in other words, that's why we say that's exactly the point. We submit with respect that this commission should not, as it were, in any circumstance where there is active dispute, consider itself appropriate to, as it were, fall in with approach taken elsewhere. I mean, because it should just set out its views.
I appreciate that, and I'm not suggesting that the PCRC might fall in with what Commissioner Finkelstein recommended. What I'm saying is that the PCRC should take into account what is happening or is likely to happen elsewhere in relation to the utility of it inquiring into issues where our terms of reference in effect require us to do that. So I'm saying that currently that recommendation has been made. The Victorian government has said that it agrees in principle with implementing those recommendations. And I'm asking you, is there any reason why we should query that? And I'll be now more specific. Your position seems to be that that recommendation is not agreed with. Do the CPH parties, are they challenging it? Are they making representations to the Victorian government to the effect that it should not be implemented?
As to the former, legal challenge, obviously, to a recommendation of a Royal Commission, short of it being beyond the terms of reference or involve procedure, there being a sort of an Ainsworth-like challenge, is practically impossible. As to, in effect, what is being done politically, it is really not appropriate, in my respectful submission, that I give such sort of materials from, as it were, what used to be called from the bar table. And in our respectful submission, this commission's views on these topics will be important, will be important for themselves. And for example, if this commission were to express, and the issue is raised, as it quite appropriately is, what is likely to occur? Excuse me, could I just take a note? I'm being informed of something. Yeah, I'll come back to this, but I think I am right, it's directly responsive to the issue you raised, Commissioner Jenkins. If you go to the terms of reference and you go to the terms of reference at D, it says, declare that to facilitate the proper and expeditious conduct of the inquiry, you are not required to inquire or to continue to inquire into a particular matter to the extent that you are satisfied that the matter has been or will be sufficiently and appropriately dealt with by another inquiry or investigation or proceeding. Now, our point is in Victoria, it wasn't sufficiently or appropriately dealt with in Victoria because the reasoning process which underpins the Victorian recommendation is, with respect, flawed. And thus we submit, in those circumstances, to the extent that you consider questions of shareholding is before you, and it clearly is, you should deal with our arguments. And if you are of the view that because of the changed circumstance to which I've adverted, which was not adequately dealt with in Victoria, the response in Victoria was an inappropriate response. And you should observe upon that in our respectful submission.
Thank you for that, Mr. Hutley. Your reference to giving evidence from the bar table, I appreciate that, but it did remind me that I actually asked Mr. Packer about this issue. And and his response was that he did not have an objection to that recommendation. So could I just highlight, although his lawyers had some difficulty with it, I think.
You're right. Commissioner Jenkins, recall that it was in the context where Mr. Packer made perfectly clear he did not wish it to enter into a debate about Commissioner Finkelstein's recommendations.
All I'm saying, all I'm drawing that to your attention, and I'm now pleased that you're aware of that, is to point out that that is the evidence. I don't ask you impermissibly to give evidence from the bar table, but that is the evidence along with the recommendation.
But if the recommendation was predicated on a incorrect premise, whether my client is prepared to go along with it or not, which in one sense, if it's a legislative outcome, they have no choice with, so it doesn't really matter, is, in our respectful submission, not to the point. The point is whether you recommend that it should occur. And that depends upon whether an appropriate response to the events which you find is to recommend such a compulsion. And in our respectful submission, as we've made, the basis for the recommendation of Mr. Finkelstein was flawed, and in our respectful submission, fundamentally flawed, such that the recommendation is if one looks at the correct position, the recommendation could only be justified as some form of punishment, which is wholly inappropriate, with respect.
Thank you, Mr. Hartley. I don't have any other questions.
No, certainly don't, Commissioner. Mr. Hutley, could I just raise with you the one question that you haven't addressed this morning, and that's not a critical comment, but in the written submissions, you deal with the issue that was raised in evidence with Mr. Packer and in the Perth Casino Royal Commission's written closing observations about Mr. Packer's absence for a long period as chair of the board of Burswood Limited. And you make the point that there's no evidence that that absence was causative of any particular problem. But can I take a slightly different approach to it and ask you for your comment on this? That as a matter of the understanding, the modern understanding of governance principles, leadership is important. Leadership is vital in a commercial operation. And if I want you to assume that there have been some identified governance deficiencies in the operation of Burswood Limited across the period that these investigations have taken, and that the absence of leadership from the person who is still the designated leader is simply not appropriate governance practice, and in that respect could be, even in the absence of direct evidence linking it in a causative sense to a particular problem, could be an explanation for some of the issues. So that if you look at it in that way, that it's an issue of principle, and it may also be an issue of practical reality, but you can certainly deal with it as an issue of principle.
I accept, and we would accept, that good corporate governance mandates the presence of the chair whilst he or she, a person, whoever he or she may be, holds that role on as regular a basis as one would consider practical or appropriate. We wouldn't dispute that, and therefore that was a departure from good practice, and we frankly conceded that in our submissions. And I would accept at a possibility level, because of the observations with respect that you make, Mr. Commissioner, that Mr. Packer's absence could have had, as a matter of possibility, and a prophylactic absence could have removed a potential prophylactic influence against one or more of the practice deficiencies which you may find. That, of course, has to be logically possible. That would happen with respect to any director. And I would accept that the position of chair may be said to have a higher probability of that occurring than perhaps a non-executive, a single non-executive director. Can I answer that at that theoretic level? And that's merely, not merely, but is the consequence of our concession that it was a matter of regret that Mr. Packer did not stand down as chair if he was not attending, because there should have been a chair, but there was at all times an acting chair in Mr. Alexander, so one that has to treat that as, with respect, a mitigating factor during that period. But I accept at a theoretic level, but that we submit is no more than to accept the matter of regret, which we have expressed in our submissions.
Thank you, Mr. Hutley. Mr. Hutley, thank you very much for your submissions. They have helped us, and we're grateful for your input. And we will now adjourn until 1:30 p.m.